Now, to another matter which has a bearing on the Supreme Court case. The tribunal investigating the conduct of suspended Supreme Court Judge Phillip Tunoi today dismissed an application by Tunoi's lawyer Fred Ngatia to dismiss the probe on grounds of unconstitutionality. Ngatia had claimed that the JSC violated the Constitution by recommending a tribunal without the presence of a formal petition by Geoffery Kiplagat. The tribunal, however, ruled that the recommendation was valid by law. Ngele was there and now reports.
The conduct of Supreme Court Judge Phillip Tunoi enters its homestretch. Tunoi's lawyer Fred Ngatia filed an application seeking for the dismissal of the tribunal on the grounds that the manner in which the probe was conducted was unconstitutional and not in line with Article 168 of the Constitution.
Article 168, 2 and 3 of the Constitution provide as follows. 162, the removal of a judge may be initiated only by the Judicial Service Commission acting on its own motion or on the petition of any person to the Judicial Service Commission.
We know that that process was not followed because what was there was an affidavit.
Tunoi's lawyer further claimed that the tribunal's scope of inquiry was only limited to bribery allegations, a bribe which allegedly took place on the 27th of August 2014, and that Tunoi's conduct prior to the 27th of August was not in question.
We all know, beyond any argument, there was only one recommendation by JSC, and that is inquire into a bribery allegation on a specific date.
This would then mean that the tribunal would have to dismiss records of text messages that were exchanged between Tunoi and his accuser, Geoffery Kiplagat. The tribunal, however, dismissed Ngatia's application on grounds that the Judicial Service Commission acted not by a petition from a member of public, but by its own volition.
It is unfortunate that a professional body such as the JSC failed to clearly specify under what limb of Article 168 it had acted. We hold that the recommendation, unfortunately framed as it was, is valid in law and confers due authority to the tribunal to inquire into all the allegations contained in the petition. That is our ruling.
The tribunal continues on the 15th of June 2016. Michelle Ngele, KTN News, Nairobi.